Hello friends, what is special leave petition? Special leave petition, you have two types of special leave petitions. One is civil and one is criminal. If you have any order of any tribunal in the country or any court in the country, trial court or court of sessions or high court, if you want to challenge it, then you can come to the Honorable Supreme Court of India via Article 136. And under this article you can file a special leave petition for the consideration of the Honorable Supreme Court of India. You can challenge them. So either it can be a civil or a criminal one. So in that scenario you have to come down to the Honorable Supreme Court of India within, the limitation is 90 days. So within 90 days you can challenge any order passed by any of the courts, the subordinate courts or the trial courts or tribunals in the India, directly in the Supreme Court of India. If there is any proper substantial amount of question of law has arisen where the tribunal or court or high court has erroneously taken some stand or a decision or passed an order or a judgment or a decree, in that scenario you can definitely knock the doors of the Honorable Supreme Court of India under Article 136. But remember, the chances of getting your SLP admitted in the Honorable Supreme Court of India are hardly 1 in 10,000. Yes, that is because there are 25 high courts in the country which dispose of lakhs of petitions every day. And also the tribunals and the courts, trial courts and all these courts in the country, thousands and lakhs of courts are there which are passing again lakhs of orders. So everybody, if they want to come and knock the doors of the Honorable Supreme Court of India, they can do it, but it will make the life of the honorable sitting judges miserable, because there are hardly 30 judges, sitting judges, and 15 courts are there in the Supreme Court of India for the entire country. So every day they have to adjudicate minimum of 500 to 800 petitions. Yes, almost 500 petitions will be adjudicated by the sitting judges of each court. So in that scenario, this Article 136 is the one which has granted the complete discretion to the Honorable Supreme Court of India. There is no right to the petitioners in this particular article. So whichever, only if there is substantial amount of question of law, that is there has to be an error apparent on the face of the record, and there has to be gross miscarriage of justice. Only in such kind of scenarios your SLP will be entertained by the Honorable Supreme Court of India under Article 136, and the Honorable sitting judges will be reading your complete petition. Your petition, once you file a hard copy as well as soft copy, your whole petition will go to the home of the sitting judges along with their convoy, and they will read in the evening. Once they retire from the court and go back to home, they will read your entire petition. Each and every petition will be read by them. If they don't have time, their interns, their law interns, their assistants will read, and they will highlight, they'll make a bullet points and they'll highlight all your points and they'll keep it ready. All your lacunas will be exposed in that particular file and they'll keep it ready. What all questions the honorable sitting judge has to ask you. And once they come into the courtroom, the decision is already being made whether to allow it or dismiss it. If they have any doubt, they will point out one or two questions to the arguing counsel. So in that scenario, the arguing counsel has to satisfy the sitting judges what kind of reason he has got to convince the judges based on the material papers that he has filed. If they are convinced, definitely they will entertain. If your case is strong, if there are merits, as I told you, 3 important grounds always count for a special leave petition to be admitted. They are error apparent on face of the record. The moment a file is opened, there has to be an error which should be visible to the judges straight away. So always keep your first point the best point, like whichever the question of law you are raising. And second thing, it is not the legal grounds or something else, the facts or circumstances kind of nonsense that the judges in the apex court look for. They look for only violation, that is question of law, violation on the law part. Okay, if there is any gross violation on the questions of law, so there has to be a substantial amount of question of law violation, then only your special leave petition will be entertained. And last but not the least, there has to be a gross miscarriage of justice. You should have been deprived from getting justice in a very miserable and dire state. In such scenario, your special leave petition can be accepted. And above all, your drafting has to be excellent. triple excellent, okay, and your arguments also has to be crisp and triple excellent. You will put only 1 or 2 points. If you put 1 point in order to substantiate it, you will kill another 2 or 3 minutes minimum. And if you put two more points, you will kill another 5 or 3 or 4 minutes. The whole, if you are raising so many points, then you need at least 10 to 15 minutes to satisfy the court. That much of time will not be provided to you. Hardly what you get is 30 seconds, 10 seconds, 20 seconds. That's all. Not even a minute. So be be on your toes. Be well prepared with all the page numbers, pagination, which important document is there, and what are all the questions of law you have raised, and which is the error apparent on face of the record you want to bring it to the kind consideration of the honorable court. All these have to be on fingertips for you. Then only the honorable sitting judges in the Supreme Court will entertain your petition. So as I told you, all the three important aspects on which you can get a relief from the Honorable Apex Court of India and special leave petitions. Yes, you need an advocate on record who is only the person authorized to sign on the petition. So whichever SLP you are filing, he has to certify it, and then only it can be filed. And apart from an AOR, you need an arguing counsel who is most important. Arguing counsel will be mostly responsible for drafting of your petition and arguing your petition in the Honorable Supreme Court of India. So this person has got almost 99.99% of all your weight on his shoulders. So try to be very careful in choosing an arguing counsel who has got a good amount of decorum and experience, and in drafting as well as arguing. These all things matter a lot and count in the Honorable Supreme Court of India. And the next thing, apart from the AOR, as I told you, you need an arguing counsel. And once everything is done, then you will file, and if they find any substantial amount of question of law in your case, definitely they'll issue a notice, or they can straight away admit your case and issue a notice, and it will be posted for 4 weeks or 8 weeks. You're normally 2 months, that is 8 weeks. Then again your petition will be taken up. Once if the other party comes and all the other parties file a counter, then it will be ready straight away for the final arguments. The second appearance of your counsel will be the final appearance most probably. Otherwise, if you want to drag it on, which will be very rare and unusual, maybe 1 or 2 dates, that's all. But it will be done very soon. And once a leave is granted for you, that means your SLP will be converted into either a civil appeal or a criminal appeal. And once it is converted into either a civil appeal or a criminal appeal, then again after few years your petition will be a criminal appeal. Your appeal will be heard at length. Final arguments will be concluded in this particular appeal, and a judgment will be delivered. It can be in your favor, or even if the leave is granted for you, the decision of judgment can go against you. So nothing can be predicted. Everything depends on the merits of the case and the arguments and everything. The counsel's role, the arguing counsel's role is very important, because judges, they cannot go through all your hundreds and thousands of pages. The time limit for them, there are lakhs of petitions lying for adjudication. So they hardly can spend 5 minutes or 10 minutes on each petition. In that particular time, they have to go through all the important papers and deliver a judgment. It has to be as simple as that. That's why the arguing counsel has to bring all the aspects to the notice of the sitting judges, the Honorable Supreme Court, and they will be noting down all the important points. And yes, if there is any substantial amount of question of law that is arising out of your civil appeal or criminal appeal or a special leave petition, that will be referred to a constitution bench consisting of either 3 judges or 5 judges or 7 judges, depending upon the kind of question of law. They will frame 1 or 2 questions and they'll place it before that particular constitution bench. And more judges will join this, and they will be adjudicating only on that particular question of law, and they will be referring back the whole case back to the division bench, that is of 2 sitting judges. Then finally your 2 sitting judges, that is the division bench, will be adjudicating your whole matter and delivering a judgment. This is the process of a special leave petition, my dear friends. Thank you, my dear friends. Such a wonderful concept, special leave petitions. Thank you.